Buenos días.
A very good morning, dear colleagues, representatives from the distinguished delegation from Cyprus, a very good morning as well, observers, NGOs. Let's begin our meeting today. 300143, that's our meeting today. We're in a public session. We're looking at the fourth periodic report of Cyprus. Yesterday, the delegation had provided a series of answers to questions raised by colleagues, and we ran out of time for follow-up questions. So we will be picking up this morning with follow-up questions from the first round of the list of issues. I would invite you all to be as succinct as you can be in questions, and also succinct and to the point in your answers from the State Party. And then we can move on to the next part of the list of issues. I'd also like to remind the delegation that you can always send in written complementary information within 48 hours, so that the committee then has all the elements and information necessary to adopt the concluding observations. So without further ado, I would like to give the floor to somebody I've noted for a follow-up question. I've got somebody else who wants to ask a follow-up question. First of all, Mr. Shani.
Thank you, Mr. Chair, and good morning to all members of the delegation. I have one very brief follow-up question, and that pertains to the head of delegation's comment about the process of the preparation of the report. It is also detailed in paragraph 2 of the report. And the question is, to what extent were civil society groups, in particular NGOs, were involved in the preparation of the report? I would welcome any information you can provide us in this respect. Thank you.
Thank you, Mr. Shani. Next speaker on my list is Mr. Setulsing. Mr. Setulsing?
Thank you, Chairman. Very briefly, I wanted to know whether there are Turkish Cypriots in the police force, and to just as a follow-up to my question yesterday, whether there's any plan to recruit magistrates or members of the judiciary among the Turkish Cypriots, so that there's no perception of partiality, and whether there's any plan at least to look at the Constitution again, or whether that's possible outside the Constitution. Thank you.
Thank you very much.
The next speaker on my list is Mr. Olivier de Frueville. You have the floor. Thank you, Chairman. We've received a lot of information from the State Party, and I'd like to thank them for that. However, I do get the impression, unless I missed something, I get the impression I didn't get an answer to my question on discrimination against children of displaced persons, in other words, mothers and fathers who have been displaced. There was one question on the interpretation of this expression, existing benefits, that apparently is in the State Party's response, but I'd like more information on that. And secondly, do you still have some form of discrimination that remains when it comes to electoral rights? Thank you.
Merci beaucoup.
Thank you. I'd like to ask now if there are any other colleagues who would like to raise follow-up questions or any further comments. That doesn't seem to be the case. So I'd like to hand over to the delegation for answers. Excellency, Madam, you have the floor to answer these questions.
Thank you, Mr. Chairman, and thank you for these additional questions, which help me to pick up on what we haven't replied yesterday. I will give straight answers to the issues raised today, and I will say a few things on the issues raised yesterday. As to the involvement of the civil society in the preparation of the report, As we said in the first written address, this is compiled on the basis of information submitted to the Law Commissioner, that's myself, by the government departments. This is scrutinized. It's not taken on the face of it, what it's given. It's scrutinized through information given to us by monitoring bodies, like the Ombudsman, who expresses the views, and the Commission for Children's Rights. And this is to make it objective. Some of the government departments in some issues involve civil society, NGOs, in their work. And this is why we try to have objectivity in the information we give to you. We are very careful in taking on board the views of the Ombudsman or the two monitoring bodies, the Commission for Children's Rights, the Independent Authority for investigating allegations against the police, and we cross-check them. We don't reproduce the information given by government departments. This is true. And this is why we are always very meticulous to give information and as to what the state and the departments have done in response to the monitoring by the independent monitoring bodies who take on board the views of the civil society. The question put yesterday and today about participation of Turkish Cypriots in the police, in the judiciary as magistrates, in the government as ministers, in the parliament as members as parliamentarians. The answer is simple. The Constitution, as I said yesterday, I referred to the Constitution, which specifies created by communal state with participation of both main communities of the island. The answer could be simple. If the occupying forces withdrew from Cyprus, we could go back to the Constitution of 1960 and have the participation 7-3 as it was. Because of what happened in 1963, first the intercommunal troubles, as a result of which, voluntarily, in inverted commas, I mean, the authorities of the Turkish Cypriot community withdrew from the government, from the function of the government. They withdrew from the executive as ministers, from the parliament as members of parliament, from the judiciary. The state had to continue functioning. And there were legislative provisions, laws, which were found to be constitutional by invocation of the doctrine of necessity, where the state now continues to function with the participation of one community. As to the IDPs, you are very correct in raising the question again. I was going to come back to it myself. With the amendment made, which I referred to in paragraph 33 of our answers to the list of issues, with a new decision of the Council of Ministers and the law enacted last year, the access to the children of IDP men and children of IDP women, of fathers and mothers, have access to the same financial benefits currently. But what's happening now, because of the financial crisis, there are no funds to give these grants. The right is the same. There is no discrimination anymore as to the benefits. But currently this year, there have been no funds to give to either of them. This is the truth of it. As to the electoral rights, no, the discrimination remains. The reason being that all political parties are unanimous in that. They don't want things to change for the simple reason. In the Parliament of Cyprus, in the House of Representatives, we have the seats are allocated per geographical district. The two districts of Famagusta and Karinia, where they're under occupation forces, and their inhabitants do not reside there, but they reside in the government control area, they have still been allocated a number of seats. And this was based on the number of the inhabitants in 1974, roughly, with some modifications. And for this reason, the right were in the second generation after the 1974 displacement of the inhabitants of those geographical areas. It was given at that time to the offsprings of displaced males. If this is extended to the offspring of displaced mothers, the numbers would be such that the seats for the districts that are under occupation will be very disproportionate to the other people living in the government control area. And this, it's not satisfactory from the point of view of discrimination issues, but it's the reality on the ground that this is the reason that the political parties do not accept that. Then I come to some issues raised yesterday. A very important question was put about the human rights in the bicommunal negotiations. And I have to say that the inclusion of human rights issues on the agenda of negotiations for finding a settlement to the Cyprus question, to this I would respond by pointing out that the restoration of fundamental rights and freedoms to a very sizable part of the population of Cyprus is in fact the essence of these negotiations. Let me remind you that in proportion to the size of its population, Cyprus has the largest number of IDPs on a global level as a result of the Turkish invasion of 1974 and subsequent occupation of more than 1/3 of the island's territory. Any negotiated solution to the problem will therefore, by definition, go a long way towards restoring most human rights violations. Human rights issues are therefore ever present in the negotiation process, underlying the work of most, if not all, technical committees and working groups set up in this framework. Having said that, in the framework of these negotiations, a number of technical committees have been created to deal with issues that affect the day-to-day life of people, which the status quo established and sustained by the Turkish occupation army has borne. In this framework, there exists a technical committee on humanitarian issues, including the elimination of discrimination against women and the eradication of domestic violence. As to women participation in the peace process, which was asked yesterday, there is very little in our replies, but I would like to add that women have had extensive involvement in the Cyprus peace process since its very early stages and throughout.
Slowly, because it's translation.
In the framework of the intercommunal talks, women have played an important role as members of the negotiating process. Women have also had significant participation in bicommunal structures and bodies, working outside the framework of the negotiations, whose purpose is to facilitate several aspects of people's everyday life, while the occupation of 1/3 of Cyprus's territory continues. The mandate of one of these bodies includes the elimination of discrimination against women and the eradication of domestic violence, particularly through awareness raising across the island. Overall, women's participation is more than 30%. The government of Cyprus encourages NGOs and initiatives existing in Cyprus which are active on a bicommunal level and which deal sometimes exclusively with gender mainstreaming in the negotiations and furthering the implementation of UN Security Council Resolution 1325. These initiatives have frequent access to stakeholders in the negotiations, to whom they provide significant input. There was another question put yesterday about racially motivated incidents against Turkish Cypriots. These claiming to be in the area under the control of the Republic of Cyprus. With this, I would respectfully have to disagree. that the frequency of occurrence is either on the rise or alarming for that matter. Yes, there is a declining number of incidents recorded every year that may be reasonably suspected to fall under this class, and mostly we're talking about damage to vehicles. But we are really talking about single-digit occurrences, and in a given calendar year. Even a single incident is, of course, a single incident too much, too many. And as such, it is very unfortunate. But if we consider that in the year 2013 alone, for example, we had close to almost 1,900,000 Turkish Cypriots crossing into the area under the control of the Republic of Cyprus, in well over 300,000 vehicles, I would respectfully say that this phenomenon, as regrettable as it is, and I repeat, it is very regrettable, is very rare and that does not give cause for alarm. Having said that, of course, our target should and remains to eradicate such instances totally. Statistics will be submitted to you about the crossings of the border on a daily basis. I will not bother you now with numbers. They have been submitted. Okay, I'll stop at that. I think two of my colleagues have very short comments to make about Anda. Thank you.
Thank you very much. Good morning to everybody. I'll be very brief and get back to a couple of questions that were open from yesterday. As far as the granting of citizenship is concerned, I'd like to point out that the criteria for granting citizenship are clearly defined in the national law. I'll just try to underline a couple of things that were mentioned yesterday. The criteria are exactly the same for children of both mothers and fathers of Cypriot origin, whether they are Greek or Turkish Cypriots. The nationality of the foreign parent is not a criteria. There is no differentiation whatsoever on that regard. Nevertheless, there is a point in the criteria that the foreign parent has to be a person who is legally residing in the Republic. And like I said, this is exactly the same for both Greek and Turkish Cypriots. Even in cases where this criteria is not fulfilled, the applicants are informed when they are submitting their application of their right and the possibility to request the Council of Ministers to examine their case on an exceptional basis. Cases are examined in chronological order unless there are humanitarian reasons to speed up the procedure. And indeed, it is a very thorough procedure because it's defined as such in the national law. But we are currently examining our possibilities in order to review and see if there is any way to make this process a bit faster without jeopardizing the procedure. Based on the data available, there's been a substantial number of successful applications from South Asian of people of South Asian origin. If the esteemed members have different information, we will gladly look into it, but as we don't seem to have any available information. Then, as far as alleged victims of torture are concerned, the procedure for examining this claim is defined in the national law, where it says that the person who claims to be a victim of torture has to be referred to a doctor. This does not mean that the person will not see a psychologist or psychiatrist or any expert in that area if it's deemed necessary. I'd also like to stress out that even if the asylum officer suspects that the person might be a victim of torture, he or she refers the applicant to the dedicated authority. So because there have been cases where the applicant did not explicitly say it, but the officer had the suspicion that the person might be a victim. Doctors who are in that board are trained based on the Istanbul Protocol, regularly trained, and there have also been trainings for other officers who might be in contact with victims of torture in order for them to be better able to deal with such cases. The term torture, we use it as it's defined in the Istanbul Protocol, and even if some characteristics are not, there is no sufficient evidence that it's a torture evidence, it might be defined as a degrading behavior. So this really does not mean if the report says it's not torture, it does not mean that it changes the outcome of the asylum application. And of course, asylum applications are examined on thoroughly. This is not the only criteria to reject or accept an asylum application. And last but not least, no person is returned to a country where there is a possibility of him being subjected to such behavior. As far as translation is concerned, there is always a translator present during official interviews and examinations, and we try our utmost to make sure that these persons are trained for the specific context. There have been some difficulties finding experts for certain dialects, and we are aware of a number of cases, a few cases, where the applicant actually suggested that the spouse does the interpretation in order to accelerate the procedure. But we only have information about very few cases, and it was the applicant requesting it. As far as legal aid is concerned, asylum seekers have access to free legal aid in both first and second instance of their application, and they are informed about their this right orally when they submit their application in a language that they understand. And they also receive an information leaflet with all the contact details and information they might need about the competent authority of the Republic. Still, there is a big number of NGOs offering free legal assistance, and we work very closely, collaborate very well with them in terms of free legal advice for asylum seekers. Last point I want to raise is as far as detention and deportation of refugees and asylum seekers is concerned. There was a question about that, and I would just like to reiterate and underline the fact that no person, no refugee, and no asylum seeker is returned to his or her country of origin. Thank you very much.
Mr. Chairman, members of the committee, having regard that during my informative analysis yesterday I addressed 12 issues, still there were 3 issues in my capacity that I didn't answer. The first one, it was about the undetected case regarding Köprülü Aga Mosque. The other one, it was about the gang rape incident in prisons that took place in 2013, and about the number of cases that have been referred to the police for disciplinary action by the independent authority. As regards the fire at Köprülü Aga Mosque, the case was investigated by the police and classified as undetected, as you mentioned, as the police have not identified a suspect. there were inadequate evidence and no leads to follow up. As regards the case mentioned yesterday about the rape of an inmate, I'd like to elaborate a bit on it. The victim did not refer to anyone or any mechanism about his situation. It was our prison liaison that identified that this inmate might not feeling well or had any problem and referred the situation to the office of the minister, where immediately the minister instructed the prison director to send that inmate for a medical examination by a psychiatrist, the psychologist, the pathologist, and the coroner. Further, the victim was put under a protection scheme and the case was investigated and submitted before court, and it's on trial now. And the third issue about the statistical data for the independent authority, yes, they were sent 14 cases to the chief of police, 7 for disciplinary actions, and 7 for remarks in relation to on how to improve the way they investigate the cases. That's what I have. Thank you.
Thank you very much indeed. Hoy estamos trabajando mucho más aceitadamente.
We're working a lot better today. We're using time a lot better. So congratulations, colleagues. Congratulations to the delegation also for cooperating with me in that endeavour. So we'll move on to our second list of issues, second part of our list of issues, so that we can keep up the pace. And I'm referring here to the issues from 16 to 30. And in that respect, I'd like to give the floor, first and foremost, to Mr. Bouzid. Mr. Bouzid, you have the floor.
شكرا سيد الرئيس. في البداية أشكر الوفد على كل الإجابات التي قدمها.
Thank you. I'd like to thank the delegation for all the responses we've heard so far. And I believe that all of the answers we expected we have heard. So 16 and 17 and 24 is what I'm going to refer to. 16 first, pertaining to domestic workers and agricultural workers. In your answers, you gave us some details pertaining to laws on domestic workers and agricultural workers. I'd like to thank you for your answers. You said that domestic workers and agricultural workers can press charges or make complaints regarding any arbitrary conduct of which they are victims. You said that the complaints are recorded, registered with the Aliens Service and the Immigration Services, and it is those services who pass on then the case files to the other ministries. If those, the leaders or the people responsible there find that there is arbitrary conduct or any form of sexual abuse, then they act. And so the question to you is this: how many complaints have you received? How many complaints has the Immigration Services received? And how many complaints have been passed on to the Office of the Public Prosecutor if there is sexual exploitation or forced labour? Secondly, the Immigration Services, is it only based in capital, or does it have offices, branches in the areas where there are agricultural workers? You said in your answers that in 2013 there were 208 complaints stemming from domestic workers, and 37 also other complaints. What were they pertaining to? Is it linked to a sexual exploitation and a personal exploitation? Are they linked to those? In another paragraph, you say that since 2009 you have created an inspectorate or an inspection service to oversee or monitor all those persons who are not registered with the social services. But we have no statistics on that the work of this inspectorate or the office of the inspector. How many civil servants work for the office of the inspector? is my question. Also, how many persons have not received social protection and who have not been recorded or registered with the social services? In paragraphs 37, you say that the administration organises the various bodies in charge of these matters, and it is with those bodies that you establish the number of persons, who are allowed to set up assemblies or associations. What are these bodies? How many are them? And also, where do your foreign workers come from? What countries do your foreign workers come from? Is it also true that some organizations are involved in the sexual exploitation of agricultural workers? To conclude on this particular issue, I noticed that there's one question you haven't answered regarding the permission granted to domestic workers to create trade unions to defend their interests. Domestic workers apparently are not allowed to change employers either when their labour permit is still valid for their first employer. Also, moving on now to the unlawful trade of persons. You gave us information about the procedures employed to ensure that the Cypriot laws are in tune with European laws. They're harmonised. And this to combat any inhuman behaviour. Could you tell us more about that? So, moving on now to paragraph 141 of your answers, you said that women are exploited sexually. Women are subject to sexual exploitation. They are allowed to stay for 4 weeks in centres created by governments. This can be extended if the victims request that. My question to you is this: how many shelters or host centres have you created to give succour to these women? How many people among those exploited persons, what is the average period of time that these women spend in these shelters? Also, where can women go once they have come to the end of their permitted stay in these shelters? Do they move on? Are they cared for the social services of the state? In paragraph 145 now, you speak about exploited children. You've taken very important legal steps in that respect, but could you tell us how many children have been followed up on following accusations of human and sexual exploitations? Also, what nationality are these children of? Finally, despite all your positive legislative steps taken to combat unlawful trade or trafficking in human beings, I would like to note that in Cyprus you appear not to have a programme to discover or to search and find persons who are exploited within asylum seekers' services. So perhaps there are exploited persons who ask for asylum, but they do not receive asylum or the economic and social assistance that they are entitled to. And these persons could be exposed to further exploitation. So my question to you is this: are you intending to rectify this situation? Is the government intending to amend your laws to be able to discover people who are victims of sexual exploitation and trafficking within the asylum seekers? Moving on now to issue 21 on freedom of religion. Now, according to reports that have reached us, there are around 100 mosques in Cyprus in which believers cannot actually go. Believers can't have access to those mosques. In those mosques, permission is granted only to pray on Friday. Sultan Tika Mosque is one of these. People are only allowed to pray on a Friday. Religious freedom must be respected. Apparently, there is for Turkish Cypriot children, there is no vocational training in schools also, it would appear. And we've heard that 30 mosques have been destroyed. As to out of 148 Muslim cemeteries, only 3 can be used for burial rites. And in those cemeteries, there is no water either, and yet water is needed for the burial rites of deceased persons under Islamic ritual law. We've also been told that there are places where alcoholic drinks and wine is sold next to mosques, as a result of which some believers who wanted to pray in those mosques have broken windows of those outlets. As to the Tika Mosque, apparently, as I said, people are not allowed to pray on Friday. The Ministry of the Interior refused an application submitted by a Turkish Cypriot association to manage, to lead, to be in charge of this mosque. Are you considering that request? This is the information that we have received. Could you confirm this information or deny this information? And finally, Mr. Chairman, my last question, which has to do with issue number 26. The procedures followed to enable Turkish Cypriots to vote and to stand for elections. The answer we received, we've heard rumours according to which there are Turkish Cypriots who weren't able to participate in European elections on the 25th of April 2014 because their addresses were not communicated and were not recorded in the state electronic electoral roll. Now, you tell us that the amendment of the electoral laws, which would make it possible for the automatic registration of Turkish Cypriots who have an identity card, that is in place. And for those who have official residence, they can. And you said that 850,000 persons have been registered under that scheme. But during the European Parliament elections, it would appear that only 1,869 out of 95,000 persons who actually did register. According to the information we received, the lack of participation in European parliamentary elections by Turkish Cypriots is due to an amendment introduced on the European elections, apparently. And now, this amendment stipulates that Turkish Cypriots who are registered on electoral rolls must present on the day of the election a form presented by the Ministry of the Interior in which they must write their official address in places that are outside the control of the state. Now, according to our sources, this information wasn't published in Turkish language and wasn't disseminated in the media or in the written press in Turkish to inform Turkish Cypriots about this additional requirement. This is what the reports tell us. These are the allegations we've heard. Now, from these reports that have been submitted to us by human rights organisations, this amendment is tantamount to discriminating against Turkish Cypriots and thus is in violation of Article 28 of the laws in force, and it's also at odds with other laws. So my question to you is this: are you intending to rescind that amendment so that your laws become harmonious with Articles 25 and 26 of the Covenant? Thank you very much.
Shukran, Mr. Bouzid. And now I pass the floor to Mr. Shani. Mr. Shani, you have the floor, sir.
Thank you, Mr. Chair. I thank again the delegation for the many responses it provided me and the committee. I would be covering a series of issues from the second part of the list of issues, starting with issue number 18 on the crossing points. I realize that this is, of course, a difficult issue because any arrangement that is introduced in the crossing points has to be made with the cooperation with the Northern Cyprus authorities. It is important, however, in our mind that the state party would actively work in order to obtain such agreements, so as to ensure the fullest implementation of Article 12 of the Covenant. My questions in this regard is whether the state party is under the view that the current number of crossing points, namely 7 crossing points, is an adequate number. Has it formulated a view as to whether additional crossing points would be necessary? Can you update us as to whether the Committee on Crossings has met recently, and if not, why not? Would you also inform us as to what is the nature of the disagreement between the respective parties that has not allowed the UNFICYP to succeed in efforts to opening up new crossing points? What is the policy of the state party with regard to unauthorized crossing points? I'm alluding particularly to the unauthorized crossing point near the village of Pergamos. We are under the impression that with respect to the existing official crossing points, there are no significant problems on a day-to-day basis. However, we are somewhat concerned, or we would want some, at least to obtain some information about the policy concerning recognition of driver's license that were issued by the North, especially with respect to non-EU spouses of Turkish Cypriots. Can you please explain to us? I understand that they are being currently required to show their home country driver's license or international driver's license, regardless of the length of their stay in northern Cyprus. And I want the delegation's explanation for this requirement, which at times could be quite complex to meet. Moving on to issue number 19, which also deals with the issues of crossing and with respect to the Turkish settlers and their descendants. And again, I want to obtain from the delegation its position on the interface between Article 12 of the Covenant, which requires it to facilitate freedom of movement to all individuals within its territory and subject to its jurisdiction, and its non-recognition policy vis-à-vis the official acts of the authorities of the North. And I would appreciate it if you could specifically address how do you strike this balance with respect to descendants of Turkish settlers who were actually born on the island. We are also concerned about the implications of these restrictions of movement with respect to, as I said, segments of the Muslim community in the north, with respect to access to religious sites in the south, such as the Hala Sultan Teke Mosque, and the implications for this policy upon Article 18 of the Covenant by and large. And my question is whether the State Party had considered in this connection the recommendations that were issued by the UN Special Rapporteur on freedom of religion or belief with respect to Cyprus. Moving on to issue number 23, which deals with the freedom of religion in schools. And I thank the delegation for its responses, which covered largely our concerns. But I do have a few more issues which I would want to raise and obtain clarifications on. Now, you describe in your answers that there is a process for exemption out of religious services in secondary schools, which is relatively liberal. But what about primary schools? Is there any comparable process of exemption from religious services? And with respect to the exemption from attending religious classes, the question which I understood has arisen recently regards the interpretation of this exemption, namely, does it contain an exemption from being marked on the class in question, but being required to stay in the classroom, or whether the exemption actually implies that one is able to leave the classroom when religious education is being offered. I understand that the National Equality Body had taken the latter position, whereas the Ministry of Education has taken the former position. And I would appreciate if the delegation could explain to us what has been the outcome of the disagreement, which, to the extent that I've been able to follow it, was taking on between 2012 and 2013. Another issue which was raised by the National Equality Body in 2011, and again I would appreciate the delegation's remarks on this, has to do with the question of performing confessions in schools, namely the sending of the practice in some schools of sending priests into school and encouraging school children to confess on the school premises. The National Equality Body recommended that this practice would be discontinued, and I would again be grateful to the delegation whether it can comment on what had happened with this delegation. Now, with this recommendation. Now, on the other part of our question, I'm afraid we did not obtain information as to whether any positive measures have been taken in order to support religious education of non-Orthodox community on the island, including Muslims who are in the southern part of the island and wish to engage in such religious education on the basis of voluntary participation. And I would invite the delegation to complement its responses and address this issue. Now, moving on to issue number 24, which deals with conscientious objectors. And again, I thank the delegation for its answers to our questions. My remaining concerns are as follows. First, with regard to the gap in the duration of services. Whereas there would certainly be occasions where one could understand and justify such a gap, the question is whether this is something which in the eyes of the state party should be addressed on a case-by-case basis, comparing the intensity and the burdensome nature of the military service as opposed to the civil service, to the alternative civil service that is being performed, or whether it should be applied like the state party applies this on a sweeping basis, namely maintaining a constant gap in the duration of service. Our concern is that a more lengthy service in the civil sphere, regardless of a case-by-case comparison between the two forms of service, might amount to even unintendedly a form of sanctioning of individuals who are conscientious objectors, and this would raise issues under Article 18 of our covenant. I have two more remaining issues on issue number 24. One, can the state party address concerns or criticisms that have been leveled against it with respect to the age of military service, namely the ability of individuals who have not reached yet the age of 18 to join up for military service on a voluntary basis? And finally, we have received submissions also concerning the status of conscientious objectors in the North. And whereas I realize that this is something that the state party has limited control over, the situation of conditions for military service in the North, the question is whether the state party considers that it is under an obligation or it is expected to try to use its influence to the extent that it exists with the authorities in the North in order to attempt to promote respect for human rights across the island in this regard. My final set of questions relates to issue number 30, which deals with the dissemination of the report, of the concluding the covenant and the optional protocol. And the concluding observations. No information was provided to us in this regard. I invite the delegation to explain to us how will our recommendations be addressed, who is going to consider them, what is the time frame, is there any mechanism in place to disseminate the concluding observations among state officials and among the general public. I also want to touch upon the issue of civil society. The head of delegation has expressed the view, has explained to us that civil society were indirectly contacted through the various agencies, but that the report itself was written and was prepared by the state authorities, which is always the case, that the report itself is being written by the state authorities. But We have seen in many other contexts that a more extensive involvement of civil society in consultation, in sharing of drafts, in invitation of civil society to provide comments, in some cases even the introduction of criticisms by civil society on the contents of the report as an annex to this report. This greatly improves the report, it greatly facilitates the constructive dialogue, and most importantly, it greatly facilitates the internalization of the covenant within the territory of the state party. And I would invite the state party to consider next time around, I hope not in 10 years, but before that, to involve civil society more extensively in the preparation of the report, but also in the follow-up to the concluding observations. So there are good practices around in this regard, which I'm sure that the state party is able to adapt. And finally, are the concluding observations interpreted to Turkish? Is there a plan to interpret them to Turkish? I would appreciate the delegation's remarks in this regard. Thank you very much for your time and attention.
Thank you very much. Le prochain orateur.
My next speaker is Mr. De Frouville. You have the floor, sir. Thank you very much, Mr. Chairman. I wanted to put questions to the delegation of Cyprus on juvenile justice or justice for minors. This is issue 20 of the list of issues put by the committee. Now, the state party has provided very detailed answers, and I would like to thank the delegation for these answers. Paragraphs 160 onwards of the list of the replies to the issues. There are a number of issues that are still pending, though. My understanding, if I'm not mistaken, according to what the state party has said, is that there is a distinction in the treatment of minors between children aged 14 and 16 and 16 and 18, so two different treatments. So minors aged between 14 and 16 are cared for to a certain extent by an institution which in English is called the Committee for Handling Juvenile Minors, says the speaker in English. But this care is not given to minors who are aged between 16 and 18. So could we have some more clarification as to this distinction between these two age brackets? As to everything else, my understanding, I think I'm right in understanding these matters, is that as things stand, there is no specialised court or juvenile court or court for minors. That is a criticism which was levelled at the state party by the Committee for the Rights of the Child, the CRC. And my understanding is that you are preparing laws in that respect. You're giving us some indication as to what you intend to do. Could we perhaps have more details? You speak about children-friendly justice. Does that really mean that you will have judges and courts that are specifically set up for children? So could you give us more indications as to what precise date, when these laws will potentially enter into force? Thank you very much. Thank you very much, says the chair.
The next speaker on my list is Mr. Situl Singh. Mr. Situl Singh, you have the floor, sir.
Thank you, Chairman. May I first of all say that we understand perfectly the situation in which Cyprus finds itself, which may be rather frustrating, difficult, because of the what we may call an excision of its territory or this foreign occupation. And I myself come from an island far away in the Indian Ocean, where different communities live together. So we do understand this type of situation. However, the committee is concerned that the rights of all the citizens living in Cyprus should be respected, and that the provisions of the covenant should be abided by. I shall deal with issues 22, 27, 28, and 29. I see that we raised an issue which is numbered 22, but no reply was received was received from the state party. And this concerned these very small minorities in Cyprus, especially from the religious point of view, the Buddhist, Baha'i, Jehovah's Witnesses, Protestant, Christian, and Jewish communities. And the question which we put is whether measures have been taken to protect the freedom of religion of these individuals. And there have also been allegations that licenses to construct places of worship and the purchase of land for burial purposes have been refused. So could you kindly tell us whether these allegations are founded or whether they are mere allegations? Concerning issue number 27, we take note that Article 2 of your Constitution only recognizes those religious groups that are over the number 1,000 on the date of coming into force of the Constitution. And you have made a very clear reply that at the moment there are no plans to amend the Constitution in that respect. But we put a further question about the 2011 census on the issue of self-identification with respect to Armenians, Latins, Maronites, and Romas. Now, in your list of replies, you have an Annex 10, which is a questionnaire, and it is not very clear to me whether that questionnaire forms part of the questions put in the census, in the 2011 census, or is it a questionnaire that is used in schools to ask children or to ask the parents of children to provide certain information? And I would be grateful for clarification on this. And now, if these questions, if you've said that in public schools these statistics are collected, but what about private schools, and what about those adults already in the community? What measures are taken to count them as, to include them in the population of Cyprus? On issue number 28, we appreciate the lengthy reply you've given, and which gives a lot of information about measures to for the removal of linguistic, cultural barriers for Turkish Cypriots and other minorities in Cyprus, barriers which would have prevented them from enjoying their culture, etc. I have only two brief questions on this issue. One is about the establishment of the Turkish school in Limassol. You have said that as far back as 2005, the Turkish Cypriots themselves expressed the wish not to go ahead, but now we have received representations that there is a wish to go ahead. So would this request to establish a Turkish school in Limassol, would this be looked into afresh? And we are also told that near Limassol, the only mixed public school that exists is in an economically deprived area of Cyprus. So would that situation be remedied? And finally, on issue 29, which concerns Romas, we are given to understand that the number of Romas in Cyprus is only 680, and do correct this figure if it is not if it is the wrong figure. And we are also told that the Romas are not considered as a minority group, but as part of the Turkish Cypriot community. So would what steps is Cyprus contemplating to take better care, especially of Roma children in schools, and to take into account their particular cultural and language needs, and also to see to it that there's no high percentage of dropouts amongst Roma children. Being given their small number, we are of the view that this is a problem that should be fairly easy, fairly simple to deal with. So with this, Mr. Chairman, I thank the delegation in advance for their reply.
Thank you very much. And the next speaker on my list is Miss Cleveland. Miss Cleveland, you have the floor.
Thank you, and thank you to the delegation. My question involves issue number 25 and freedom of expression. And in this regard, I would like to echo my colleague, Mr. Satul Singh's expression about our sensitivities to the situation in which you find yourselves. But as we understand it, in July of 2013, Cyprus amended the law on the procedure for the standardization of geographical names to criminalize the use of unrecognized names of regions, cities, and villages, and that it is our understanding that the purpose of the law is to avoid the use of unofficial geographical terms with respect to the occupied territory of northern Cyprus. In your reply to the list of issues, you appear to acknowledge that the law restricts the freedom of expression under Article 19, but that you contend that it is valid under Article 19.3 because it is provided for by law and necessary for the purposes of protection of cultural identity and public order. Now, as you know, the committee has interpreted Article 19.3 as requiring that a restriction must address one of the enumerated aims under Article 19.3 and must be necessary and proportionate to the achievement of that legitimate purpose. And in paragraph 35 of General Comment 34, we explain that when a state party invokes a legitimate ground for restriction of freedom of expression, it must demonstrate in specific and individualized fashion the precise nature of the threat and the necessity and proportionality of the specific action taken, in particular by establishing a direct and immediate connection between the expression and the threat. So the law raises for us, too fast? Oh, sorry. The law raises for us a question whether this provision indeed serves a legitimate purpose and in particular is necessary and proportionate to the achievement of that purpose. For example, it strikes me that Cyprus might require that official geographical names be used, but also permit the use of other names. It is my understanding that this is the approach of the European Commission, whose approach is to first use the official Greek name, followed immediately by the current Turkish name, and that this is consistent in the Commission's view with UN practice. So I have three questions. First, has this law been enforced? And if so, against whom and for what conduct and with what outcome? Second, I would welcome any specific and individualized information you can give us regarding how the goals of public order and cultural identity are served by this law, and why these goals could not be achieved through some less restrictive measure, such as the approach of the European Commission. And then finally, I would also welcome information from the distinguished delegation regarding any international precedents that the state considered in adopting this measure. Thank you.
Thank you very much. ¿Algún otro colega que quiera?
Any other colleagues who'd like to take the floor? Mr. Politi.
Thank you, Chair, and I would like to thank the delegation of Cyprus for their presentation of the report and the answers provided to us. I have a couple of additional questions with regard to the issue number 20 relating to the right of fair trial in juvenile justice, an issue that has been touched upon by my colleague de Frouville already a few minutes ago, especially with regard to the new proposed legislation. What I would like to ask is first, if there are any statistics available with regard to the number of offenses committed by both children under 18 years old and adults. In other words, with regard to cases of complicity. And second, what will happen in these cases with regard to the court that will be competent in adjudicating the cases, whether there will be the ordinary courts or the juvenile courts still will have competence with regard to the minors. Furthermore, would there be any impact of these situations on the types of premises in which the offenders are imprisoned? In other words, would there be an increased risk in the circumstances that a minor is not imprisoned in a separate facility? Thank you.
Thank you very much. Bien, no debería decirlo.
I perhaps shouldn't say what I am going to say, but we're doing pretty well with the time. So I think maybe we can be a little bit more flexible as regards our time management. I will give the delegation until 11:30, within which time they can prepare their answers, and the chair thanks the colleagues for their cooperation. And we will resume then with the answers to the list of issues, and then we'll have follow-up questions. I'm pretty sure colleagues will have more follow-up questions. So the meeting's suspended until 11:30.
Colegas.
Colleagues, welcome back. Let us resume our exchange and our consideration of the fourth periodic review of Cyprus. The delegation has put together answers to the questions put to them previously by colleagues, and I'm going to give the floor to the distinguished head of delegation for her to begin the responses. Your Excellency, you have the floor, madam.
Thank you, Mr. Chairman. As it's been the practice, I will deal with some issues of general application, and the other members of the delegation will take more specific issues. As to the first question put in relation to sexual abuse of people in general in Cyprus and the combating of sexual abuse, I would just want to refer you as a general framework to paragraphs 138 onwards in our answer to issue number 17, where we speak about a new law that was enacted and came into force in April 2014. This law was enacted for the better implementation of all instruments under the UN auspices relating to the subject and in harmonization with the relevant EU law. This is mentioned in the reply, and we have more information on this law. This law, as I say, came into force last year, and it's being implemented in relation to cases, new cases committed thereafter. So when we'll be next reporting in 4 years, not later, I promise that, otherwise I will resign, we will have progress too, because the reason for this enactment was to handle best the issue. But specific answers to a question of what the situation is now and what has happened will be given by the expert in the department. There was a question only on issue 18. And I think the reply is given in paragraph 157, where we say that within the context of the bicommunal negotiations under the UN Secretary General Good Office's mission, the government has proposed the opening of a number of new crossing points as a confidence building measure, and this was rejected by the other side, and Ambassador Nadir will give more information on that. Now, the policy on driving license. I heard with great interest the point made on this issue, and again, I have to refer you to paragraphs 158 onwards, whereby we explain that by the accession of Cyprus to the EU, naturally, the whole of the territory of the acceding state, that is the Republic of Cyprus, acceded to the EU. But because part of that member of the EU now is under foreign occupation, special legislative provisions were made by the EU and agreed with Cyprus, the acceding state, because the so-called green line, the imaginary line, which is called green line, dividing the two parts of the island, is not the outer EU border. One of them, the most important being the so-called green line regulation, the reference is in our answer to the list of issues. And this regulation, it's EU legislation implemented by the authorities of Cyprus and provides specific rules as to how this EU member state, which is Cyprus, will implement EU law and protect people and regulate the free movement of people and goods. The part relating to the crossing of vehicles across the green line has to do with the obligation of Cyprus to implement EU legislation in relation to what qualifications drivers should have if they are going to be allowed to move into EU territory when they're crossing the line. And this is abiding by the EU regulation 1071/99, establishing common rules concerning conditions to be complied with to pursue the occupation of road transport operator as well as the relevant national, and this was harmonized, it was implemented by national legislation. So the authorities have to request anybody who crosses the line to have a license which is in compliance with EU rules, and this is what's happening. And it is for this reason, if I understood the question well, some nationals of other states who may not be having the valid license issued by the authorities of Cyprus, which is normally requested, they may produce a license which is accepted in another EU member state to make it easier. But this is the reason. There is valid license issued by the legitimate authorities of the state members to the European Union, which is applicable to everybody. It's not an issue of discrimination. And the Turkish Cypriots have been duly informed of the requirements to acquire this license, which is issued by the competent department of Cyprus. And I am obliged to say here that it is the Turkish Cypriot leadership which has proven to be preventing and discouraging Turkish Cypriots drivers and operators from obtaining the necessary documents in the context of its policy to contest the existence of the Republic of Cyprus. But what the authorities are doing, they're applying EU law as being the territory of the European Union, Cyprus. Now, there were questions at various, I'm taking the questions as they were put to us about schools and the exception from the religious classes and from religious services. There has been monitoring about that, of the practices of the Minister of Education from the Commissioner for Children's Rights. And the Commissioner has said that exceptions should be made, and they're made, but the exceptions should mean that the children requesting this exception, or the parents requesting for the children's exception, when parents request, the child should be given an alternative class, an alternative subject to do, which is equally educational. They should not be allowed to stay in class. They should not be sent out to play in the schoolyard. Sometimes I'm in the embarrassing situation to confess that sometimes this is done, sometimes it's not done. There is no consistency in that. In relation to the confession, there has been again monitoring and report by the Commissioner for Children's Rights, stating clearly a very lengthy document, taking on board all human rights instruments and practices and pertaining in other countries where the predominant religion is the Greek Orthodox, this is it's my own country, saying that the school is not the appropriate place for confessions for those who wish to confess, and it shouldn't be taking place. It's not yet uniformly, it's not yet done in all schools. There are situations where this is not, where this practice still takes place. Again, it's embarrassing to confess it, but it's the truth. There was another thing, question on issue 24. No, the other issue was about conscientious objectors. Yes, the legislative provision provides that alternative service should be 33 months. You're very correct in that, whereas the armed service is 24. The reason given by the appropriate ministry for that is that naturally the armed service is more onerous. It entails exercises, marches, military shots, and education, and it's very onerous, and it's far away from one's place of residence. Whereas alternative service is civil service, usually with a local authority or somewhere, which is near the place of residence of the person who is doing that. And there is no case-by-case examination. There is this provision in the law which is applied without discrimination to the few cases where there is an application for that. The number of applications, throughout the period under review is given in our answers to the list of issues. But I have here more information that there have been very small applications in recent years. And the information given is that up to this day, there have been no complaints or appeals either to the Ombudsman or to the court in relation to the decisions taken by the authorities on this issue. Another question put related to the recruitment of people under 18. The answer again lies with Cyprus ratifying the optional protocol, the relevant optional protocol to the CSC, and Cyprus has ratified that on 2nd July 2010, depositing at the same time a declaration. And in this declaration, it explains how the instances where there will be voluntary recruitment of people after they have completed, of children after they have completed the age of 17, is fully compatible with Article 3, Paragraph 3 of the optional protocol. And in the declaration itself, which is posted, explanation is given for this reason. I can read it out, but I won't do it for the saving time. This is available, as you all know. There was a question where, as to the situation in the occupied part of the island. The answer is very clear. Unfortunately, it's an area which is beyond the control of the legitimate government of Cyprus, and it's being controlled by the occupation forces, and unfortunately, we have no bearing. We only have reactions. Maybe the ambassador could give more information on that. It's beyond my competence. The next very good question, all of them are very good, but this one is the one I like. It's the dissemination of this information. What we're going to do with your concluding observations? What will happen, they will be forwarded to the Council of Ministers by me with my views, recommendations on your concluding observations, how that they should be implemented. What will happen is that the Council of Ministers will decide that the competent ministers and their departments will look into them carefully and consider them and see what measures we have to take in order to comply with them. In the past, Cyprus hasn't had a very good record in that. But in the very happy situation to report that recently we had a very good practice with the CEDAW. The concluding observations of the CEDAW what made the element, the basis for the new strategy for women. And it was on the basis of the CEDAW recommendations that the action plan was drafted, and all the measures for implementation that the state would have to do and the various departments were elaborated on. And I like to believe, and I will insist on that, that this will be the future, the fate of all concluding observations of all treaty bodies. As to translations, we try with translations, even with Greek. There is a problem which I mentioned yesterday in another context with the Turkish language, finding the human resource to do the translations because of this unfortunate situation. We don't have Turkish Cypriot compatriots in the government departments, which makes it more difficult, but an effort will be made towards that. Another question which touches the bottom of my heart is that on juvenile justice. We have information in the answers to the question to the list of issues from paragraph 160 onwards. I will, the experts from the departments will speak about the situation up to this day. I will speak about the new legislation which was drafted by the Law Commissioner and Children's Commissioner and is taking on board the Council of Europe guidelines on a child-friendly justice. This new legislation, which has been submitted to the President of the Republic because it was one of his priorities of his policy program to the competent Minister of Justice and other ministers, and it's been discussed now, and I have been informed by the minister that we'll start discussion next week, which is the first step to see what we're going to do. We'll start discussion. It's a very big legislative framework, which takes care not only of children when they have reached a stage of delinquency, even before that. It deals with prevention, like all guidelines and all international instruments. It deals with prevention even before the age of 14. 14 is a landmark because it's the age of criminal responsibility for Cyprus. We deal in this legislation, this bill, with how prevention, and then we start dealing with children after the age of criminal responsibility, and there are new structures there for children to be dealt by committees comprising all multidisciplinary specialists on children's issues, psychologists, pedagogues, lawyers, yes. How, and taking out of the court system, as a general rule, delinquency by children. And having alternative, of course, your children will have to learn that the society has limits and how they should behave. But then there will be alternative measures. And it's going to be, under this new law, the exceptional case where a child will go to a court. And under this law provides for the establishment of a proper juvenile court. Because, as you know, and we have said it before, what we have now, it's called a juvenile court, but it's not. It's the same judges sitting a day saying, I'm a juvenile judge, I'm a juvenile court today. There are some safeguards for the child witness, or for nowadays, for the child witness and for the child victim, or for the child who is before the court. But under the new scheme, there was going to be an absolutely different court, different building, different judges, properly trained in juvenile justice and children's rights issues dealing with us. And there are a lot of safeguards. I could take the whole out, and you don't want me to take the whole out talking about that. But again, under this new legislation, the privation of liberty of the underage, of the minor, is going to be the last resort measure. I'm optimistic that the process has started. It requires a lot of discussion. It's a new framework, and it's new innovative measures. And we've taken precedents from other countries. But as I say, it's an attempt to comply with all international standards on a child-friendly justice in the general term. There was a question on issue 27, Article 2 of the Constitution. This cannot change as the situation is now under the existing Constitution. As you're probably aware, the Cyprus Constitution is a very strict Constitution because, as I mentioned yesterday, the terms of reference of the drafters of the Constitution was to implement political agreements and the London and the Zurich agreements. And for this reason, some articles were specified, stipulated as basic articles, and there is no provision for changing those articles. There is a procedure, a special procedure for changing some of the articles of the Constitution, those that are not basic. But one cannot touch the basic articles of the Constitution, which are the ones relating to the two communities. So this one, I'm afraid, cannot change until a solution is found to the political issue, when this solution will be covered by a revised constitution or a new constitution. We know that there is a problem with the national minorities, but it's in the hands of the political leaders to expedite the procedure. Now, Turkish Cyprus and school, and the school in Limassol. The school in Limassol, it's a school where, because of where it's located, and I must say in Cyprus there is a legislative provision whereby children are bound to enroll in the school of their locality. You can't choose a public school throughout Cyprus. You have to go to the school of your locality. And this is a very strict rule. So ethnic minorities, which tend to live in the same locality, are found to be the majority in any public school. This happens with other schools. And the ministry has this in mind and takes special measures, one of them being the educational zones, which I mentioned yesterday. I'm not going to get into that again. But there is this special school in Limassol Agios Antonios where the majority of the children are Turkish Cypriots or Roma, people in Cyprus. The peculiarity of the Roma community in Cyprus is that it's not a fixed community. It's people who come from the Green Line, from the north, and they come and go. It's the nature of this community. They're on the go, they're on the move. They stay for some time in the government control area, and then they move. When they're in the government control area, most of them are in this area in Limassol or in another area in Paphos, where they go to some schools where, again, they are more or less the majority, or if not, in big numbers. A lot is done in this school. This was visited by the Commissioner for Children's Rights, and there is an extensive report on what has to be done to cater for the needs of the Turkish Cypriot students and the Roma students and their families. What has to be done by the Ministry of Education and the Ministry of Welfare as to their families. I'm in the happy position to report that the Minister of Education took on board all the recommendations of the Commissioner, visited the school, and committed himself to gradually implement those. So I hope when we next report in 4 years, we'll have good news to report about that. As to the standardization legislation, it's issue 25. In our paragraphs 175 to 177 of the list of issues, we tried to give the legal answer. You're correct. In a law, you don't put the reasons that led you to legislate the way you did. The government, the state, feels that this was justified under paragraph 3 of Article 19, as we say. The reason being that in the northern part of the island, there is a systematic policy to illegally change the original and internationally accepted geographical names of towns and villages, the toponyms, as we know them. Geographical names of towns and villages as are historically recorded in various inscriptional, historical, geographical, and other archival sources, which form an indispensable part of the cultural heritage of the island and constitute part of the tradition of universal toponymic nomenclature inheritance, are being changed. This act of changing the geographical names in that part of our country constitutes an unauthorized interference in the affairs of an independent UN member state and flagrant violation of the international law. Moreover, they are contrary to United Nations resolutions as the Resolution 111/16 on national standardization, Third UN International Conference 1977, and I can read it if you like, and Resolution IB/19, the recognition of national standardization, Fourth UN International Conference of 1982. And I would also like to mention that all legal geographical names of the Republic of Cyprus are included in the complete Gazetteer of Cyprus. There are about 67,000 entries, and this was submitted, this Gazetteer, to the 5th Conference on the United Nations for Standardization of Geographical Names, held in Montreal, Canada, in August 1997. This Gazetteer contains all legal geographical names, including Greek and Turkish names. And this is what the state is trying to prevent. And this is what the state has found that it was legitimate under paragraph 3 of Article 19 to legislate on. I will stop at that. I think I've covered the other things, and I will give the floor to Ambassador Grandiu to complete
Thank you very much, Mr. Chairperson, and with full respect to the Chairperson and to the member of this committee, I don't want in any way to politicizing the meeting of this particular forum. But since there were some questions that they are political questions, I have to give some answers. And I would like to apologize myself because I don't have any legal background as well. When we are speaking about all this issue regarding the Turkish Cypriot compatriots, the source of this problem is not the approach of my government. The source of this problem is the Turkish invasion in 1974. The source of this problem is the 40,000 military troops, Turkish military troops, that there are still remaining and occupying a territory of the Republic of Cyprus. Regarding the occupied areas, unfortunately, we don't have any influence on the implementation of the human rights. What we try to do, we try to implement the human rights of all people who are in the control areas of Cyprus, either they are Turkish Cypriots or Greek Cypriots or any other nationality. Having said that, I will try to respond to some questions, specific questions, and is the question of freedom of religion. We have an excellent cooperation with the Professor Bielefeld, who recently made his third visit in Cyprus. Last week, he presented his annual report in the Human Rights Council, and the only reference regarding Cyprus, it was as an excellent example for interreligious dialogue. I'm not going to details how many mosques there are in the occupied area of Cyprus, how many mosques there are in the control area of Cyprus, how many churches there are in the occupied area of Cyprus. Because I didn't hear anything about the churches and the restoration of churches in the occupied area of Cyprus. What we do, we have an excellent cooperation with Professor Bielefeld. We try through the UNFICYP, who is present in Cyprus, to work together with the Turkish Cypriot compatriots for the restoration of all cultural places, churches, mosques in Cyprus. I will try to add something regarding paragraph 157 regarding the cross points and the question by Mr. Shani. When we are speaking about cross points, we are not speaking about cross points in legal borders between two countries. Unfortunately, we are speaking about cross points in a ceasefire line in my country. And the control of the ceasefire line is not by the Turkish Cypriot leadership, but is still by the Turkish army. And when we are speaking about opening new cross points or not, is not something that we are so easily can arrange with our Turkish Cypriot compatriots and the Turkish Cypriot leadership, but we have to do with the Turkish army. We would like to have more crossing points, but unfortunately it's not the case. And the question it was why this committee has no meetings in the last months. And the answer is not only this committee. We don't have negotiations in the last months. And the reason that we don't have any negotiations in the last months is that the President of the Republic of Cyprus temporarily suspended his participations to the negotiations. What was the reason for that? The reason for that, it was the violation of the economic exclusive zone of the Republic of Cyprus by Turkey. Turkey sent some military vessels in the area, and President decided that he stopped to negotiating anymore under military threats. I have to add something regarding the access to the movement to religious places. There we don't have any restriction either to Muslim or to any other nationality. The problem there is the legal or illegal point of entry in my country. When we have a legal application for issuing a visa by anyone to come in Cyprus to visit a religious place, we are issuing a visa and there is a free access to the religious places. But regarding the settlers, that they are in Cyprus in an illegal way and from an illegal point of entry, we are not able to give any free access to the control area of Cyprus, not to religious places, to the control area of Cyprus. I think I covered all the issues that I wanted to. Thank you.
Thank you for giving me the floor. Good afternoon, everyone. I will try to address as many questions that fall within the competency of the Department of the Ministry of Labor and Social Insurance that were asked by the members of the committee. There was a question on the complaints mechanism established to examine the complaints by migrant workers. Let me briefly describe the procedure. The complaints are firstly filed, as was correctly said, in the Aliens and Immigration Department, where they are stamped and recorded. Then they are given to the Labor Relations Department, who undertake to invite both parties and listen to them. Everything is taken down in writing. An investigation is carried out. The whole procedure is carried out both in Greek and English, so as to achieve a clear understanding of both sides. Then a report is prepared, which is sent to the Migration Department for final decision. If any violation of the employment contract is evident, remedies are imposed to employers through legal procedures and other internal mechanisms to ensure that these violations will not be repeated. In addition, permission for new employment is given. These complaints generally concern disagreement on terms of employment, alleged breach of contract of employment, etc. However, the labor relations officers, during the investigation of the complaints, identify trafficking issues or sexual exploitation attempts. And if this is the case, the complaints are sent to the competent authorities for further investigation and related actions. The question also concerned statistics on these complaints. Briefly, during 2004, 962 complaints were filed in total. 799 complaints concerned domestic workers, while 163 complaints concerned agricultural workers. 234 complaints ended in a release agreement where the worker was given permission to find another employer, and 21 complaints were resolved by the employee choosing to go back to their employer. 46 of those employees were repatriated. There was a question on the inspections that are carried out and numbers for those inspections. We have established mixed inspection units of inspectors that handle various branches of employment. They try to enforce equality laws, but they also try to find employees that are not registered with the Social Insurance Fund. In 2004, 8,072 workers were found that were not registered with the Social Insurance Fund. 1,433 undeclared workers were identified. I'm sorry, the total number of workers examined was 8,072. 1,433 of those are undeclared workers. 34.68% of those were Cypriots, 50% were EU nationals, and 15.14% were non-EU nationals. Concerning the question on whether domestic workers are given permission to register in trade unions, the answer is yes, they can. There was a term in the contract before that did not allow for them to be registered in trade unions. That provision has been removed from their contract, so they can now register in any trade union of their choice. There was a question about the shelter. It's true that the victim of trafficking can remain in the shelter for 4 weeks. However, the stay can be prolonged for as long as necessary. The average of the stay is 2 to 4 weeks. After that, of course, the victim is provided counsel, advice. Welfare officers can mediate for the easing of the better integration of the victim into society. They can make arrangements for any medical examinations or care that might be required. And they can act as the link between other services that might be involved in the whole process. They can also make arrangement for alternative accommodation. If you have any follow-up questions, I'll be happy to address them later. Thank you.
Thank you very much. I'll also try to be as concise as possible. I'll pick up where my colleague left regarding the identification of trafficking victims. And like the head of delegation has mentioned, there is a new law which was specially enacted to better implement all relevant treaties under the auspices of the United Nations, but to also harmonize our legal context with the relevant EU directive. I will just highlight the main changes and innovations of the new law, but we would be happy to get back to you if you need more details. You can also refer to our list of issues. There are several pieces of detail there. The new law contains provisions for a more effective handling of all the cases related to trafficking. There is a special focus on convictions and punishment of perpetrators, but also the treatment of victims with a full respect to their rights. This new law provides a more supportive framework for the victims of trafficking, and it also penalizes the use of services by victims of trafficking, which is an innovation. It also provides for the setting up of a fund in order to cover their needs, whether they are compensation or legal assistance related, and so on and so forth. There is also a new provision for the external evaluator of the application of this legislation, who will examine the trends, evaluate the statistics, and conclude and suggest possible further actions in order to combat trafficking in human beings. What is more, and what is we consider quite important, is that this law allows victims of trafficking to remain in Cyprus instead of being repatriated for humanitarian or other reasons, and they can enjoy a list of rights according to their needs after risk assessments have been made by the experts. What is more is that victims have access to their rights even from the reflection period, so it's not necessary for the procedure to be completed to establish whether somebody is a victim of trafficking or not. They have access to their rights even from the reflection period. Also very important to mention is that in the multidisciplinary group, there are several representatives from NGOs who are actively participating in the implementation of the legislation, but also the new action plan that is set for the combating of trafficking. Like I said, I will be glad to get back to you with more information, but I will also like to mention something about asylum seekers being victims of trafficking. In this context, the Ministry of Interior, along with a multidisciplinary group, are systematically organizing trainings and awareness-raising campaigns in reference to trafficking. And in this context, and in reference to handling cases for international protection by victims of trafficking, there are specialized trainings made to officers in the asylum service. So right now, there are officers who have received the training needed and are specializing in handling cases for international protection coming from victims of trafficking, given the obvious vulnerability of these people. As far as child victims are concerned, I will also make a very short remark on that the new law contains special provisions about the protection of and treatment of child victims. Even in cases of unaccompanied child victims, there are special, very, very clear provisions in order to protect them. A social welfare officer is also present always when the child is asked questions regarding its case. A short reference, as far as domestic workers are concerned, I would like to inform the STEAM committee that we are currently examining the criteria for the employment of domestic workers, along with the criteria for changing employers, with a view to simplifying the procedures and introducing provisions to better protect their rights. We are in the process. We hope to conclude the process within the next 2 months, I hope. As far as the electoral rights of Turkish Cypriots are concerned, all Greek Cypriots and Turkish Cypriots residing in the areas under the effective control of the government need to apply for their inclusion in the electoral lists. This is the same for both Greek and Turkish Cypriots. There's been an amendment in the electoral law to include people, Turkish Cypriots, living in the areas which are not under our effective control, which provides the automatic inclusion of their data in the electoral list, provided that they are holders of a Cypriot ID. There have been some very few exceptional cases during the last elections where such people were not allowed to cast their vote, and based on the data we have available, they either did not possess a valid ID or could not otherwise prove that they were permanent residents of the Republic. I hope I've covered most of the questions in... Yeah, thank you.
Thank you very much. I'll briefly address 4 issues that they were raised. There was a question on whether Turkish Cypriots are recruited in the police. The answer is yes, if they fulfill the recruitment criteria that are listed on the website of the police, and given that they pass the exams and the fitness test, they can be recruited in the police. The other issue, there was a question with regard to the number of cases investigated by the police for sexual and labor exploitation in 2014. There was only 1 complaint about labor exploitation. The case was investigated by the police and was submitted before court for prosecution. There was a comment regarding the juveniles in prisons. Rightly, the vulnerability of juveniles dictates that they should be heard as a matter of principle separately from adults. And we don't have a center for juveniles, but however, there is a well-staffed unit, and they are held separately from adults. They are engaged in purposeful activities, and they are provided with a full range of educational, sport, and recreational out-of-cell activities. And we have juvenile treatment in prisons until 20 years old. In very rare cases where there are out-of-cell activities together with adult prisoners is permitted or even beneficial as stated by CPT on the strict condition that there be appropriate supervision by staff. And there was another question as regards the number of cases reported in the police with regard to juveniles. There were 26 cases in which 40 minors were involved under 16. Thank you very much.
Muchas gracias. Thank you very much. Quiero, antes de las preguntas.
Before we have the follow-up questions, I'd like to start by thanking you, delegation, for the answers you've provided. And let me reassure the head of delegation and the ambassador, sir, and others that colleagues here do not ask political questions. They are speaking in their personal capacity. These are 18 individuals of high moral and ethical integrity, and as this is something that is stipulated in the ICCPR, and of course are not representing any governmental viewpoint. Questions are raised as regards the implementation of the covenant. The state answers. Very often they have to answer and talk about situations that arise. And all this enables us to understand the situation better so that we are better placed to adopt our concluding observations. So I just wanted to make that clear. This is a public session, both for the delegation and indeed for the NGOs and observers, and anybody who may indeed be following this on the webcast. And I think we're having an extremely important dialogue and useful dialogue. And following on from this, and within this spirit of cooperation, let's continue with follow-up questions. The first speaker on my list is Mr. Shani.
You have the floor, sir.
Thank you, Mr. Chair. I wanted to really echo your comments to the delegation. We're not interested in the political dimensions of the conflict. I acknowledge the sensitivities. I come myself from a country that has a green line. We are interested in the implementation of the covenant, and we ask countries before us questions about the way they implement the covenant in their territories. And to the extent that they have some influence over non-state actors or other actors operating in their territory, we also ask them whether they're using their influence in that regard. We certainly do not take sides in any manner and respect with respect to the very difficult conflict in Cyprus. I want to follow up on two issues. One relating to the, again, to the driver's license, which is perhaps not a major issue, but I think it is somewhat of a litmus test as to what extent is really the conflict or human rights taking front seat in this issue. So if I understood correctly, the position is that the driver's license policies are determined by EU regulations. But I find two difficulties with this answer. First being that I understand that the Republic of Cyprus does recognize driver's licenses that were issued in northern Cyprus for those residents of northern Cyprus that do not have citizenship of another non-EU state. And whereas if the same license would be issued to a resident of northern Cyprus that does have the nationality of a non-EU state, typically the spouse of a Turkish Cypriot, then this would not be recognized. So I find this policy somewhat inconsistent, And even more so, since the European Commission itself expressed concerns last May about the changes that were introduced in the policy and that actually led to the non-recognition of these driver's license, I find it hard to accept that this is an implementation of EU policy when the EU itself is expressing some concerns about this policy. So I would just want a clarification here. And now on the issue that was raised by my colleague Mr. Siddelsing on the question of civil service and Turkish Cypriots, and it was just commented with respect to the police. I did understand the answer concerning the suspension of the constitutional order in the 1960s and the doctrine of necessity as justifying why you do not meet your constitutional standards, namely the 70-30% arrangement. But if I understood correctly, the argument is that there is no constitutional limitation, even under the state of necessity, to recruiting minority populations into the civil service. And the question from our point of view, why has this not been tried more aggressively? As we always ask questions, countries that have national or ethnic minorities, we try to encourage them to integrate these minorities within the civil service and the judiciary in order to promote their equality and integration in society. And I was not sure what are the legal hindrances that exist for the state party to implement this policy. Now, I did understand that there is not, if I understood correctly the observations, there is no legal bar against recruiting minority populations, including the Turkish minority. But the concern that we have received is that what in actuality bars this population is the Greek proficiency test, which is being employed, and I understand it's a rather strict language test, which makes it more difficult for members of minority populations to join civil service. This is particularly hard to justify with respect to the Turkish to the Turkish minority, given the fact that Turkish is an official language of the state of the Republic of Cyprus. So they are in a somewhat anomalic situation where, for access to a civil service, a Turkish Cypriot is in a less well-off situation, say, than an immigrant from Greece who has just arrived in Turkey and has maybe a very good Greek proficiency standard. So the question is whether the state party is aware of the language barrier, and whether it acknowledges that there is a language barrier, and whether it is taking or planning to take steps in order to ease that language barrier in order to promote the integration of Turkish Cypriots into the civil service. Thank you very much.
Thank you very much, Mr. Shani, and I will pass the floor to Mr. Boussid. You have the floor.
شكرا سيد الرئيس.
Thank you, Mr. Chairman. First, I would like to thank the delegation for the extensive information that they have given for the questions I have raised. I still have a couple of points I haven't heard any answer and reply about. The first point is about the private employment agencies, those private employment agencies that bring all the workers from abroad. I know that you have issued very strict regulations to control the work and operations of the private employment agencies. My question is, did you see any illegal activities conducted by those agencies, like the sexual exploitation of domestic workers, or also cases of forced labor regarding the agricultural workers? Did you discover cases of that type? Did you discover that there are agencies that are involved in sexual exploitation or forced labor? Second question, regarding the question that I have raised about the freedom of religion and thought. Thank you for the reply that you have given, but I didn't get the answer about the mosque of Tika. Do you want to open this mosque during all the days of the week, not only on Friday? Because during the other days of the week, it's a museum and not a mosque. So what you intend to do about this place of prayers and worship? Would you open it other than on Fridays for believers? And we know that we have also an attempt where this mosque may be used for other purposes. I haven't heard a reply about the cemetery or the graveyard. I have told you that we have only 3 cemeteries for Cypriot Turkish people that are valid and can be used for Muslims. What do you intend to do about the other cemeteries that are not used for that purpose? And thank you.
Shukran, Mr. Boussid, and now I pass the floor to Mr. Sital Singh. You have the floor, sir.
Thank you, Mr. Chairman. Just to follow up quickly on what Mr. Shani has said, when I look at Article 159, paragraph 2 of the Constitution, which I understand has been suspended, it says, a court exercising criminal jurisdiction in a case where the accused and the person injured belong to the same community shall be composed of a judge or judges belonging to that community. And that was, I understand, in the context of the original Constitution. And this, in fact, is to me very surprising, although it's a reality. It was a reality. And I would, in fact, be more in favor of putting all citizens on an equal footing, and that even citizens of one community could be judged by a judge from a different community. And that would be the ideal solution in the long run, because whether it's Greek Cypriots or Turkish Cypriots, they have to be put on an equal footing in Cyprus. And finally, I thank you for the clarification about the Romas, but this prompts me to put another question about the conditions for employment of Romas. So does it mean that because the Romas are in nomadic people, that they move, did I understand correctly that they can move from Cyprus to North Cyprus freely? And that in that case, the situation about education or employment is a difficult one, and does not, and therefore they are not in fixed employment or in a fixed place for the children to be able to attend schools. Thank you.
Thank you very much, Mr. Sital Singh. Pregunto a los
I ask the colleagues, turning to the colleagues, does anyone else wish to make a follow-up question at this stage? Any statement, comment, query? I see no requests for the floor. Therefore, I turn back to the distinguished delegation of Cyprus to give them the chance to answer these follow-up questions. You have the floor, madam.
Thank you for this clarifying questions for me as well. About the driving license, probably I did not express myself correctly. What I'm saying is that, yes, Cyprus is implementing the Green Line regulation together with the other regulation on the driving license, which is EU law, on behalf of the EU, and it's requiring people to use the driving license, to have the driving license, which is issued by the legitimate authority of the member state, which is the government of the Republic of Cyprus. What I was saying, I never intend to say, and I'm sorry if it sounded like that, I do accept driving license of spouses or of anybody issued by the TRNC, the illegitimate authority in the north. What I was trying to say, and I want to make it clear, is if people, spouses or other people, have valid license which are under EU law accepted in EU member state, these are also accepted, which are accepted under EU law. We don't say because they're married to a Turkish Cypriot or they live in the occupied part of Cyprus, so don't accept them. because these are equally valid. I never meant that to accept any driving license issued for anybody by the legitimate authority in the north. You mentioned EU concerns. I'm sorry, I'm not aware of those. We'll come back to that if you can give us more information after the session, and we'll reply in writing about that. Recruiting minority population in the civil service. The civil service is open to anybody who fulfills the requirements, anybody who lives in the Republic of Cyprus. Under EU law now, all cases are open to EU nationals, including Cypriots, and people living in Cyprus, with those exceptions specified by EU law. So any minority who fills the requirements can be recruited, and any Turkish Cypriot will be accepted, even though, strictly speaking, under our constitution, Greek Cypriots and Turkish Cypriots form the two communities. What I meant to say about the constitution, and you're correct, sir, the constitutional provisions do not apply to the extent that the state to function has to have a percentage of 3 to 7 in the court, the provision you just read. This was tested in the Cyprus courts and in the court of the Privy Council in a case called Mustafa Ibrahim, which related to Article 159 of the Constitution, which you mentioned, sir. It was a criminal case where a Turkish Cypriot was tried by composition only of Greek Cypriots on the basis of a law enacted, Law 33 of 1964, which was enacted subsequent to the events of 1964, when, as I mentioned more than once during these sessions, the Turkish Cypriot community as a community withdrew their members from the branches of government, the courts, the parliament, and the government. And the state had to continue functioning. And officially, the percentage which is put by the Constitution could not be met. So all posts were filled by Greek Cypriots or other people who could apply under that. And that was found by the court in Cyprus at a time where the composition had the Turkish Cypriot judges, and that's very important because the judges were the last ones to leave. First one was the ministers from the executive, then the members of parliament stopped participating, and then the judges were the last ones to leave. They were participating, and they found this law to be within the Constitution by invocation of the doctrine of necessity. And this doctrine was upheld in the case of Cyprus in many decisions of the Privy Council, the organ of the Commonwealth, the highest judicial organ. But this is exactly as you put it. It's to say why the state of Cyprus was found to be the legitimate state and the government of the state by the European Court of Human Rights and the Luxembourg Court in subsequent occasions, which are not for the moment to elaborate on. But I repeat, any individual belonging to any minority group who can sit the examinations and fulfill the requirements will be recruited. And even Turkish Cypriots who, strictly speaking, are not a minority, but are de facto minority for purposes of human rights issues, and we accept that. And that's why there is a conscious attempt and effort, as we should do as a country, to safeguard their rights, will be accepted. And I'm informed by the ambassador, which I didn't know, that in the foreign ministry, a Turkish Cypriot was given the chance to take the examinations in Turkish. But the fact remains that from the two official languages under the Constitution, the Greek and the Turkish, only the Greek one is used officially because of the lack of the Turkish element in the public sector to take part in promulgating laws in Turkish, in issuing judgments in Turkish, in issuing official documents under the doctrine of necessity. It was in Turkish or in Armenian? He was an Armenian, I'm being told, but he took the examination in Turkish because he was more fluent. But then any person who joins the civil service or a government service will have to be able to function and understand, or with the Greek language, with some help of the English, which a lot of people use. I think Mrs. Andreou will say something about employment agencies later on. We take note of the two questions, which you are very correct, sir. We did not reply about the Tika Mosque and the cemeteries. I don't have the answers. We'll send them in writing. unless one of you has. Okay, sorry. Then maybe it will be answered later. The Roma population, yes, it's a nomadic population. But they stay for some time in the Republic of Cyprus. And when they're in the Republic of Cyprus, they can work as any, in the minds of the people, I know this won't sound correct, it's like Turkish Cypriots. They go to schools, and there is an effort because attending schools until the age of 16 is compulsory, and it's a criminal offense for any parent to leave a child out of the school. There are conscious efforts to see that these children are attending school regularly. But the reality of the matter is that the reports we have from this school authority and from other school authorities, yes, they look for them, and then they find out from the locality that the family has moved again to the north, or they will be coming back. This is a reality. But you're correct. Dropout should be prevented, and there is a efforts to prevent it. But if the family has moved elsewhere, there's nothing you can do. But I repeat, it's a criminal offense for any parent in the Republic of Cyprus to leave a child out of school until the age of 16, which is compulsory education and free education. And it's an offense for the school not to pursue this. Yes, it's important to mention that for the Greek Cypriots, public schools are free. Private schools, they pay out of their own pockets. For Turkish Cypriots attending private schools in the government control area, this is covered by the state, these fees. As well as for other minorities. Armenians, there are schools for Armenians in the Armenian language, and for Maronites, there is one school. These schools are covered by the state budget. I think I finished. I think the ladies, Mrs. Andreu.
I can answer very briefly on the private employment agencies. I thank the distinguished member of the committee for recognizing the strong legislative framework in place. Let me just tell you that in 2014, the Department of Labor, which is the competent department for this law, has examined 24 complaints and has sent to the police for further investigation and prosecution of the persons involved, 7 cases that concerned illegal operation of private employment agencies or exploitation of workers. We have also revoked the license of 2 private employment agencies because these did not comply with the instructions of the competent authority and the relevant provisions of the law. Very briefly again, in addition to what the head of delegation has said about the employment of the Roma, I would like to inform you that the public employment services offer placement, vocational guidance to Turkish Cypriot job seekers, including the Roma people, irrespective of whether they live in the government-controlled areas or in the Turkish-occupied areas, provided that they have a Cyprus identity card. They are offered support in finding an appropriate job position. They can participate in subsidized employment programs offered by the Department of Labor, and they can also participate in training programs organized by the Human Resource Development Authority. Thank you.
Thank you very much. Very briefly, in reference to the mosques, all the mosques in the government-controlled area, in reference as far as their opening hours, access matters, and so on and so forth are concerned, those are regulated by the Muslim community. The exception of the Hala Sultan Teke having opening and closing times, it's because it also operates as a museum, so the personnel there needs to have those hours, but it is accessible on a daily basis for everybody. One further piece of information I would like to mention is that the Dali Mosque, which is only open on Fridays, the reason being that the hygiene facilities are not proper. I just like to inform you that the the expenditure will be covered by the Republic, or is being covered by the Republic, to improve that, and so it can be open on every day, like the rest of the mosques in the government-controlled areas. I hope that clarifies a bit that issue on the working hours. Thank you very much.
Okay, I know, and sorry, understand we have an answer about the cemeteries. On that we'll come back because we don't have the answer. Thank you. As well as the nation.
Thank you very much. Muchas gracias. Veo que ningún.
I see there are no further requests for the floor from colleagues. This dialogue has been extremely rich. I now will give the floor to the head of delegation once again. Your Excellency, for you, Madam, to share with us your final conclusions, and after you have spoken, I will seek to give you a short summary of the debate we have had. So, Madam, Your Excellency, you have the floor.
Thank you, Mr. Chairman, distinguished members of the committee. At this stage, I would like to express my delegation's deep appreciation for the very constructive, interactive dialogue we encountered yesterday and today. As I mentioned earlier this morning, your concluding observations will be submitted by me to the Council of Ministers, which is the highest organ of executive power, so that instructions will be given to the competent ministries to duly consider all your recommendations in the formulation of government policy and the planning of actions. And I feel confident, as I said earlier on again, that we will have further progress to report in the course of the next cycle review in 4 years. Respect of human rights, including civil and political rights, is a top priority for the government of Cyprus. Despite the economic difficulties currently faced, which have affected all areas and sectors of life, I assure you, sir, that we are determined to continue our coordinated efforts to enhance, promote, and safeguard the human rights of all people in Cyprus. I thank you, Mr. Chairman.
Thank you indeed very much.
I think that we've had a very rich dialogue, a very interesting dialogue this morning and yesterday with Cyprus. Much time has gone by since our previous dialogue, but perhaps it was worth waiting in order for us to have such a significant dialogue, such as the dialogues we've just had yesterday and today. Many of the issues that have been discussed today and yesterday have been based on a fundamental principle of international law and international human rights law, which has acquired the highest ranking, and that is the principle of non-discrimination. This principle really binds states supremely. Of course, states are bound to respect all provisions of international human rights instruments which they've ratified, but the principle of non-discrimination is, so to speak, a cornerstone, a golden piece of the international human rights law. And much of what we have discussed yesterday and today has been linked to freedom of conscience, non-discrimination, and freedom of religion, which requires not only the state respecting this, but also guaranteeing, ensuring that it is respected, this principle, through its public policies. We've heard what you've said about your public policies, and you will not be surprised to find in your concluding observations some requests or urging of you to go a little further in this implementation or in this embodying of the principle of non-discrimination in your public policies. Of course, we've raised matters pertaining to the displacement of people and the consequences thereof, and other significant issues linked to disappearances that took place in the past and the efforts made by the state to seek to address and resolve past disappearances. As a number of colleagues have pointed out, perhaps this is the right time, a good time for this Committee on Enforced Disappearances to look at its mandate. The head of delegation was recognizing that the mandate was limited, and perhaps Cyprus could consider extending, enlarging this mandate so that justice, truth and reparation could be awarded to people who've suffered from enforced disappearances, because, as you know, these crimes of enforced disappearances do not have a statute of limitation, should not be bound by a term of limitation by definition. Also, those persons who are detained, the state naturally has the responsibility to respect the rights and the integrity of the persons deprived of liberty. So we've raised all of these matters, we've talked about these matters, and we've talked about specifically the guarantees, the assurances that the state must give to persons who find themselves in greater state of vulnerability because they are migrants. And we've heard information from you on that particular status. We've looked at the freedom of expression also, and 19.3, Article 19 through, and the different points of view thereon. I urge you to look at our general comment number 34, which was adopted a few years ago in the committee, and which sets forth guidelines to guide the state in the interpretation of that particular article. The head of delegation has been very eloquent in the way she's addressed her answers. She's been very enthusiastic in the information she's given us. And I'm from Latin America, and I recognize eloquence when I see it in the answers that you've given us. But now these 4 years, I understand that you want to come back to visit us quickly, and we'll be delighted to see you again, but we do not have a 4-year rule. But the committee, in its concluding observations, will put a date for which, at which you will have to return. And of course, as I said before, we will be equally pleased to see you once again with open arms. But before you come back to see us, in due time, we will be communicating to you these instructions. So we have a follow-up procedure, and that has a 1-year term, 1-year deadline. And in that follow-up procedure, we expect full cooperation from the state. As you've been so courteous with us, the 48 hours become 96 hours, and that's because you have the weekend. No preferential treatment, that's because you have the weekend. So it's 48 hours, which become 96 hours for you to send any additional information. So once again, on behalf of the committee, thank you very much. We wish you a very safe return to Cyprus, and we will now adjourn until 3 p.m. And this afternoon, ladies and gentlemen, we have a closed session to consider communications. Perhaps the Secretary would like to tell us more. Kate, you have the floor.
Thank you, Mr. Chairperson. Just to confirm to the members that there is an NGO briefing this afternoon. It's a thematic NGO briefing on conscientious objection. So all of those who are interested in this topic should attend in the usual room RS 181 at 2 o'clock. Thank you.
Okay, se levanta la sesión.
We adjourn for this morning.